Hello, and welcome to this week's episode of Real Estate Ready. I'm your host, Jerrod Pickering, a real estate agent up here in North Texas, ready to help you out this week. So today, what we're going to be looking at is seller contracts. We're going to look at what a typical seller contract may look like. We may or may not talk about percentages and some of that kind of stuff, but just the different parts of the form for you to look at and be prepared for whenever you sit down with your agent. Let's get into it.
The purpose of this video is to review the common listing contract here in the state of Texas. There could be some others if it's a commercial property or things like that. We're going to look at just the standard residential real estate listing agreement with the brokerage agency having the exclusive right to sell. So let's get into this contract here. And again, a lot of what we will talk about is what we see most commonly. Each contract is negotiated with between each brokerage and the client. But we can look and see what you'll see most commonly. So let's get into it. So of course the first part is the parties. And again, the parties are it needs to be all parties involved in the sale of the property. So usually it's just one or two people, but if there's more, then those names need to be included on this form, and they also need to sign as well. Of course, you have the broker, and this is an important distinction. When you're going into contract, you are going into contract with the actual broker. Now, that may or may not be the agent that will be listing your property and guiding you through and helping you understand this contract and getting your signatures. But there will be you're going into contract with that broker with an agent acting as a representative of that broker. And so that's what the purpose of this contract is that you are appointing the broker, um, that one broker has the exclusive right to sell your property. And that includes even over you. So then we have a property description. You probably know your own property as just your address, and that will go here as well. But there's also an official recording of location of your property that will be in the title, and that there's usually a lot number and a block number. And that's where you'll put this stuff here. Your agent will help you fill this part out. It's not something you uh, as the client will fill out. So these next few sections are very important. These are showing all the things that will commonly stay with the home that you're listing. Anything that's permanently affixed. So while your TV hanging on the wall, the TV may go with you when you sell your home, but the fixture attached to that wall could be described as something that should stay with the home unless you include it in the exclusions section down here. If you've got built-in speakers, like a built-in sound system and things like that, those usually stay. Refrigerators kind of go back and forth. Now stoves and built-in microwaves. Now a countertop microwave usually will go, but if it's built in like over the range, over the stove, then that will stay too, unless again you put it in the exclusions clause that we talk about. Another big one that people don't think about are fireplace logs. The fake ones, those ceramic fireplace logs, they're very expensive. They usually will stay with the property uh, unless otherwise excluded. Okay, and that's what some of these accessories here you see here. Anything that helps, um, that assists in uh, the operation of the home, and so that does include those artificial fireplace logs that you see right here. If you want to exclude any of that stuff, this is where you will exclude it. Sometimes your agent will also say that this is where you will also exclude like mineral rights to the land. In a lot of cases, you may not, if especially if this is a subdivision, a neighborhood. Chances are, you as the owner don't have the mineral rights to your property anyway. That those were retained by the original developer. That's definitely something that you'll need to have a conversation with your agent about, though. Moving on, Section E, this is where you'll let your agent know, your broker know, if the property is subject to any sort of HOA, homeowners associations. And if there is, you need to be able to provide the documentation for that homeowners association, because that will be something that will have to be delivered and signed off on by any prospective buyer. Number three, listing price. This is a price that should be agreed upon. Your agent will give you a market comparison and analysis, also called the comps, telling you what they think that the price should be listed at. In the end, it is your decision, and this is where y'all agree that this will be the first price the initial listing price. We talk in other episodes about how to decide on a listing price, again, because I know that it could be difficult with if it was a home that you had custom built for yourself, that there may be some um, emotional attachments to the property that may help make your decision. And so your agent will help you through all of that, but in the end, it is your decision. So the date that the listing will begin, and there needs to be an end date. In fact, by law, there has to be an end date. Um, it may be 3 months, maybe 6 months, maybe a year. Again, this is a negotiable part of the contract between you and your agent, but make sure that both blanks are filled out. You cannot have just an open-ended contract. There needs to be an expiration date. Now, you can always extend it if you're getting close, but there does need to be an expiration date. Section 5, the broker compensation. Please notice that this is a blank. This is something else that's negotiable. I know automatically everybody always thinks, oh, they're going to get 6%. Typically, we do see that 6% of the sales price is a part of it, but this is also very negotiable. In some cases, where if I'm going to sell your property and help you find another property, I may only say I'm going to charge you 4%. 3% to go to the buyer's agent, 1% to me, but then you have to use me to help you buy another home. And so, in the end, that might save everybody some money. So, again, it's not always just a straight 6%. Please know that there are some discount brokerages and national companies out there who will come in and say, okay, we're only going to charge 4%. Please make sure you read the fine print. Make sure that they're not trying to make up those charges somewhere else. Sometimes they have copying fees. Sometimes they may have property management fees while the house is under a listing. Please make sure you're paying attention to all that, and don't just look at that percentage number and make your decision based solely on that. And then you can see number two, there might be some other types of compensation that might be uh, available too. So when is that compensation paid out? It's earned whenever at closing, when the house successfully closes, um, or if you back out, you breach the listing, you back out of the contract. That could be it could be earned at that time. And anyway, a lot of the fine print will determine when that's earned. But typically, in a normal contract, we're not going to get into all the ifs and what ifs, all that kind of stuff. We're basically this is on a normal contract. It'll be paid to the agent at closing. Um, if you do try to back out of the contract and you breach the contract, then that doesn't you you still owe. that compensation to your agent. This number three, the other fees and reimbursable expenses, this is what I was talking about a minute ago. Please pay attention. If there's anything in this, that could cost extra money, you definitely want to have a good understanding of that. Protection period. Protection period is, let's say you find a family member or something that maybe wants to buy your property after you've already entered into your listing agreement, and you decide, um, that you want to just fire your agent and sell it because you have your own buyer. Then this is where that protects that listing agent for a set period, that if you try to sell it yourself after firing. Now, if you fire them for cause, that's one thing because they breached their end of the deal. But if you just wanted to get it to save yourself the percentage, then this is where that protection period, that so many days after you fire, especially if it was somebody who's already come and seen the home and showed the home, then this is where you would still owe that agent that percentage that was listed above in the contract. Uh, Section F. Usually, I know I don't particularly put anything because we don't usually pay anything in cash. Escrow authorization gives your listing agent the right to work with a title company to act on your behalf to set up an escrow for this listing if needed. Number six talks about Section 6 talks about the listing services. So usually, you work with a multiple listing service, also known as MLS. Um, your agents are usually members of at least one MLS in their local area, and this is the section where you decide whether or not you want it listed on the MLS. This will allow other people to see it. This will allow other websites like Zillow or Trulia or Realtor.com or some of those to pick up the listing and display it on their website as well. And so here's the instructions on, that within 5 days of this listing beginning, it needs to be on MLS, or you give the instruction that you don't want it filed with the MLS, that you want to help your agent to help you find a private buyer. And again, your agent can discuss when the right time to do that type of stuff. Most of the time, though, you will have your your property listed on MLS, and so that's what um, this section defines. Access to the property. So, for people to purchase your home, they're going to want to come look at it. And so if the home is going to be empty, if the property is going to be vacant, then of course that's one of the easier situations. Then people can come and look at it pretty much just about any time. However, if you're going to be continuing to reside on the property while it's being listed, then this is where you start setting up times and you start giving your agent directions. For example, a listing I recently did, the sellers required me to be present at all showings, and be able to let them in. They did not want a lockbox put on their home. They did not want a scheduling service to be used. They wanted it to be done through text, email, and phone with each buyer's representative. So this is where you'll make duplicate keys so that the agent can have access to the property. Um, this is where those decisions will be made. Sometimes a scheduling company will be used where the buyer's agent can automatically schedule showings, and they notify you when people will be on your property. So again, if you are living there, that maybe you can be gone while they're showing the property. um, Cooperation with other brokers. This is the section. So in a 6%, let's say it's a 6% listing, this is where you can say, we're going to pay you 3%, and we're authorizing you to uh, allow 3% to be paid to the buyer's representative. And this is the section that talks about that, you know, MLS participants versus non-MLS brokers. You're talking about maybe if it's another agent from out of state, you've got to make that decision too. Are you going to allow them to be paid? If there's going to be a sub agent, are they going to get a percentage of any of this? And again, all of this, you see, all of these are blanks, and so it is negotiable. The intermediary status. Hopefully, by this point, your agent has already gone over with you what an intermediary does. This will allow, if you allow intermediary status, that means other agents within the same brokerage um, may represent buyers that are interested in your property. At that point, the broker's role changes in the transaction. Um, and again, your agent should go over this with you because there will be another form called the information about brokerage services, in which all of that will be discussed with you. And if you don't want your property to be shown to agents within the same brokerage that are representing those buyers, then this is where you can select that option as well. And this gives you this little section, this little notice section here, kind of gives you a little bit more information about it. But again, you should already have reviewed this with your agent through the information about brokerage services page that you signed. Section 10 deals with confidentiality. As your agent, don't discuss your finances or anything else with any other than my broker. But we don't discuss it with the other agents or anything else. We don't discuss with the agents how high or how low you're willing to go or anything like that on the property. Um, Section 11 talks about marketing uh, your home on the internet. Most brokerages have their own website, maybe Facebook's, other social media pages where they might want to advertise. Um, Also, Section C deals with what type of. Section C deals with the type of financing offers that you will accept from potential buyers. Um, some might ask, well, why is that a big deal? Wouldn't we want all buyers to bring whatever financing options they have? Yeah, that's one way of looking at it. Sometimes people don't want to deal with well, for example, owner financing number 6. Owner financing means you as the seller would act as the bank, and uh, that you would be taking monthly payments. Um, and you may not want to do it that way. You may just want to do cash only. You may not want to wait for an FHA loan to clear or any other type of loan. You may just want to get straight cash for your property. And so there are instances where you want to be selective, and your agent will help you answer any questions you have about that. This section D talks about the what like for sale signs that can be put on the property, different types of marketing that may be used. Um, Um, this also authorizes your agents to do any search to make sure there's no other liens against your property, like tax liens or a mechanics lien. Again, your agent can kind of go over some of those different types that might be out there on your property, but um, it also gives your agent the right to mark when your property is pending under an option period or that it has been sold. Um, uh, it, Section E is very important that the broker is not authorized to execute any document in the name of or behalf on the seller. So what that is saying is I cannot enter into a contract with a buyer on your behalf. I have to review every contract that's presented, every offer that's presented. I review with you as the seller, and you are the ones who will sign executing the contract, not your agent. But we do, as an agent, um, we can represent you, at least verbally, when visiting with appraisers, title officers, the buyer's agent. Um, and other people who may have inquiries, potential buyers. Um, we this mean this also acknowledges that your listing agent may be involved in other transactions as well. I may be listing your property, but I may be helping another buyer acquire another piece of property. Um, some of these other things here, like letter E, that the seller is current and not delinquent on all loans. So that's basically saying that you've kept all your mortgage payments; they're all up to date. You don't owe any taxes. You don't owe anybody anything where they might come in and try to take your property. And that's or any other encumbrances on the property. So if you've given your neighbor the right to build a fence that they're part of the fence that might be on their property, that could come up in the survey and everything. And so it's best if you've given permission for all that, then that you disclose that at this time. Um, you also are agreeing that you're going to do your best to cooperate with your agent and the agent's broker, um, providing timely information, being available if needed to sign documents. Um, if you're residing on the property that you're trying to sell, that there are reasonable times when you can be gone, so that the potential buyers can go and take walkthroughs of the property and stuff, and just being reasonable. That's what a lot of this is. There's um, nothing crazy here. It's most of it is just being reasonable. If your property that you're selling, um, if you're not living in it and all of a sudden you decide you want to lease it out to somebody, if in the listing, during the listing period, if you decide you want to go ahead and lease your property to somebody and give them a 1 year lease, um, the potential buyers need to know that information. So you need to discuss that with your agent first, because if you allow somebody to sign a 1 year lease and you sell the property, well, then the new buyer becomes the landlord, and that may not have been what they wanted. They may have wanted to move in with their own family, and now they've got to wait until that lease ends to be able to take possession of their property. So make sure uh, that you're just keeping lines of communication open with your agent. Your broker is not responsible. If somebody comes onto your property to review something, or to do a walkthrough, and they steal something, your broker and your agent aren't responsible for that theft. And so that's what this limitation of liability section uh, deals with. Um, Special provisions, very seldom is anything written right here, but again, if so, then that will be done under the advice of usually a legal entity of a lawyer or somebody like that. Section 16 deals with if you decide to break the contract, um, what that looks like and how much you would still owe your brokerage. And if y'all couldn't get along, what type of mediation would need to be done, and who's paying the attorney fees for those. So this last section here, the addenda and other documents. So under uh, when you're selling your property, typically you'll have a seller's disclosure notice. It looks something like this. The seller's disclosure notice. This is where you, as the seller, will sit here and fill this form out, and this is where you will put all the different sections that are here. Uh, what items are in the home that you know of to your fullest extent of your knowledge? Are you aware if there's any problems, if there's been any major repairs, if there's been any flooding, if you filed any insurance claims, how old is the roof, that type of stuff. And this is all done by you. Your agent cannot help you at all with this. This is your responsibility as the seller to fill this out, because this will be provided to any potential buyers, and they will sign off saying that they have received this. But again, this has nothing to do with your agent, other than your agent will give you a copy of this for you to fill out and sign, and they'll keep it with the listing. But your agent does not help you fill this seller's disclosure notice out at all. If your house was built before 1978, there will be another form that you need to fill out regarding lead-based paint, the possibility of lead-based paint, and whether or not you know of um, anything there. The residential real property affidavit, also known as the T-47. If you have a copy of your survey already and you want to attest that nothing has changed since that survey was taken, then that'll be another form that you fill out. And this will be provided. The title company and the title company's underwriter still may require another survey to be done, and that will, as a part of the buyer's contract, either that'll be paid for by you or by the buyer, depending on whatever's in that contract. But this gives the opportunity that nobody would have to pay for an existing survey, and that could save hundreds, if not thousands, of dollars in some cases. Um, uh, if there then there's some other documents that may need to be made available. Again, if you're a member of an HOA, anything regarding the HOA. Um, Out here where we are in North Texas, we have on the outskirts of the Dallas-Fort Worth area, you've got a lot of septic systems as opposed to being on city sewer. And so if you've got a septic system, there's another form you have to fill out regarding what you know about the septic system. If you own minerals, if you and you're wanting to retain the mineral rights, again, if you're kind of in a more rural area where you might still own your mineral rights, there's an addendum covering that. If you in a low-lying area that's a flood zone that you know about, there's forms for that. Again, um, all of these all of these are situational specific, so we're not going to get into all of them, but that will be done on a case-by-case basis by each property. And so then finally, we get into these. These are this. A lot of this is just fine print. Um, uh, Talking about wire fraud, talking about how if you are a foreign person, as defined by federal law, that's required to be disclosed at this time, and then you will put your signatures here, as with anything through not only just the real estate process, but anything in life, any type of contract that you are uh, signing. If there is something you don't understand, you need to consult your attorney and make sure you understand it before you sign. Don't just sign and ask every question that you want to ask, and make sure that everything that you need to know, and make sure you understand it. And that's, again, a good rule of thumb in any part of your life. I hope this was helpful for you, and uh, we'll see you next time.
I hope you found that beneficial for you. Again, every contract, every part of it is negotiated with your agent. Make sure uh, that you are keeping an open dialogue with that agent, and we'll see you next time.